Hi everyone, welcome back to Litigation Help. My name is Heather Hui-Litwin. In this video, we're going to talk about how estate planning differs depending on whether you're legally married or in a common law relationship in Ontario, Canada. So joining me here today is our regular contributor to Litigation Help, Samuel Michaels. Samuel is a lawyer in Toronto. He has his own legal practice called SMLegal. His practice areas include business, employment, wills and estate law. Sam has appeared with me on many live seminars at the Toronto Public Library. He has his own YouTube channel under the name Samuel Michaels, and he has also been a guest on a number of videos here on this channel. I'm going to have the links to these videos in the description box below. Welcome, Sam.
Thanks, Heather. Yeah, great to join you again for another video. I think this is our first Zoom video, so it's exciting to be doing this new format.
I think so, yes. So Sam, could you tell us about some of the things that we should be aware of in estate planning for married and common law couples in Ontario?
Yeah, I think it's an interesting question because when it comes to married versus unmarried, which is also sometimes called common law relationships, if you're doing everything right in the estate planning and you're taking all the necessary steps and putting the plan together, really the process shouldn't look so different, right? You're accounting for your spouse in the future, to make sure that they're financially taken care of, to make sure that the property that you want to pass to them is going to pass on to them, that the assets that you want to go to them are going to go where you intend. And with a common law partner, it's really the same process, right? You're looking at that partnership and saying, okay, what can I put in place to make sure that they're maintained in the future, that they're financially supported, that the property that they want is going to them and that I want and expect to go to them is actually going to be passed on. So in that sense, as long as everything is sort of being done proactively, being done in advance, or being done with an eye to the future, a lot of those steps are going to be the same. In fact, at the end of the day, the document, the will, and what it actually says is going to be pretty much the same language, right? I allocate X amount of dollars to such and such person. It's going to be basically the same. It's just going to, the change is going to be, the name, my wife, so-and-so versus my partner, so-and-so. Where it can get different, where things can get tricky is when there is no will, right? When there hasn't been a proper estate plan put in place. It's not the end of the world. The government still accounts and our legal system still accounts for these situations without a will. It's not that all your money gets locked away or goes to the government or anything like that. It still gets passed on, but it gets passed on according to what's called the intestacy rules, the intestate succession rules. And it's the Intestate Succession Reform Act, which is the law that basically governs all this. And that act basically says that if you pass away and you don't have a will, your first $200,000 of net worth goes to your spouse. There's a bit of an exception because the spouse can also elect for net family property instead. I'm not a family lawyer. I know you'll have lots of other great people on the channel to talk more about that type of situation. Generally, the spouse takes basically the first chunk of the estate. And then any amount over 200,000 gets distributed to the children. If there's no children, to the parents. If there's, to the grandchildren. If no grandchildren, to parents, and so on and so forth. The law lays out all these steps. Right? If not this person, then this person, then this person, for all these different family relations, because the goal is that the estate goes to the family. Right? The government, they're not trying to take people's estates. They're trying to set it up. If there's absolutely no family whatsoever, there is a situation where it can get kicked back to, I think it's like a trust foundation essentially that uses the funds for charitable purposes, but it can revert to the government. But that is a absolute last case. So I think there's a big perception about like, oh well, if I don't have a will, I'll lose all my money. Generally that won't happen, right? It's only in the case where there's absolutely no family, no extended family whatsoever. But I'm sure you've caught from what I'm going through with these intestate rules, the common law partner is not included, right? They're simply not in there. So if you have a partner and you pass away without a will, that partner doesn't have any automatic entitlement to the estate. There are two ways that they can still get some value from the estate, but both of those are, I guess, what you would call complicated legal proceedings. So that's either a dependent support claim, right? So there's a concept developed by the courts and by law, basically says that if somebody is dependent on another party or on a partner, um, and that partner passes away, they still have a reasonable entitlement to the continuation of that support if they're dependent on that support. The other grounds that you can take a claim for it as a partner is an unjust enrichment claim. So that would be a claim to say, for example, one partner paid all the rent and all the expenses for the other partner to go through school. And then once the partner completed school and went on to a successful and lucrative career, they passed away without a will. The surviving partner in this case could likely make an unjust enrichment claim, say, I contributed financially to make this happen, right, to lead the person to this wealth and success. Now I have some entitlement to some of the results of that, right? All the effort and resources that I put in initially. So as I'm sure is obvious just from describing these claims, these are not simple processes, right? This isn't, submit a one-page form and get your check. These are long processes that generally require going into court and making a claim and proving it, and lawyers get involved and judges get involved. It's a cumbersome process, to say the least. So I think when you're planning, though the result in an estate plan is very similar, right? It's a will for your spouse, a will for your common law partner, same document at the end of the day. The incentive is much higher with the common law partner because they actually will be left out, right? If you pass away without a will, whereas your spouse will still be somewhat accounted for. They may not be accounted for exactly the way you envision, but they're not going to be left out entirely, right? So I think it's more so the burden on the individual who's doing the estate plan being a
Right.
little higher, right? Versus the actual mechanical documents being different, right? At the end of the day, it's still your will, your power of attorney, your living will, your healthcare directives, right? Same things get put in place.